Okay, let's go on the record on cause number. I'm sorry, okay, it went away. Can you, Ms. Pettit, go ahead and announce the cause number and the case name?
Yes, Your Honor. The case is Mark Holm and 5 Points Holdings versus et al. Versus 5 Star Global et al. Cause number is DC 20-08643.
Opposing counsel?
Good morning. This is Sarah Krajewski on behalf of defendant Southfield.
And this is Maria McIntyre and Cliff Riley on behalf of defendant 5 Star Global.
Okay, before we get started with this, I want to share screen something and just kind of explain something. So that we're here on a motion to strike or enforce a jury waiver, is that correct?
Yes, Your Honor.
So when I try to pull this up on the system for the motion to strike, it just gives me a notice of hearing.
Your Honor, it may be because this case is under seal, and I know that sometimes the clerks have problems when we file things under seal.
Okay, I just don't, I'm not disagreeing with you. I haven't had a chance to find it because what was listed there was the notice. And so
I have a copy of the file stamped version, so I know it has been file stamped. I can certainly email.
Do you know what day it is? What day you filed it?
February 24th, 2021, and the file stamp is at 5:54 p.m.
Let me see, February 24th.
Yeah, it looks like it's not on the docket. I see an entry for the 24th that says motion, but then my guess is if you click on it, yeah, I bet it's that motion to strike. Oh, passed it. On the 24th, it shows a motion. On the 24th, it shows a motion to strike, but I don't think you can click on it.
Where is it? Oh, there yeah, you're right. There it is.
Would you like me to email?
I guess so, yeah. I assume that Ms. McIntyre, that you got a copy of this motion, her motion, right?
We did. My secretary had to contact Rhonda and get it from her a while back because it was filed under seal.
Okay. I guess go ahead and email me directly as well as all the attorneys a copy of the motion so I can read it. I've read the response.
Okay.
And it sounds like the defendants are relying pretty heavily on this River Center case, but I haven't seen the motion. Or was there a reply filed, or I didn't see a reply?
There was not, Your Honor. No.
Okay.
Give me 1 second. I can send it. Do you want me to send it right now or send it after the hearing?
Well, I'd like to be able to read it before we get started. So yeah.
I will copy Mr. Riley on it. I don't know that I have all of the other counsels.
Just Mr. Riley's okay.
Okay. All right. Give me 1 second. Okay. It is headed your way, copying Mr. Riley. And may I use the share screen feature, Your Honor?
Yeah, let me go ahead and stop sharing, and you can.
Okay, it says you need to enable it.
Oh, sorry about that. Go ahead.
Okay. So as Your Honor is aware, this is our motion to strike the jury demand. There's 3 different waivers, Your Honor, that are in place in this case. Let me see if I can click over. Here we go. Okay, so there are actually 3 waivers in this case. And as Your Honor, I know you're very familiar with this case, so I won't belabor the point, but we've got highly sophisticated parties on both sides. It's a private equity transaction gone wrong, essentially. And so we're not talking about anyone here that is not a sophisticated party. And there's actually 3 jury waivers. There's the asset purchase and contribution agreement, which we all call the APA. There's Mr. Holmes' employment agreement, and there is a master services agreement. All of those contain big, bold, capitalized jury waivers in there, which Your Honor will see in the motion once you're able to review it. So there's 3 waivers in there that the parties contracted for since day one when they entered into their agreement with one another. The standard, obviously the Texas Supreme Court has said that a conspicuous waiver provision in a contract is prima facie evidence of a knowing and voluntary waiver and shifts the burden to the opposing party, in this case, the defendant. I don't think there's any even argument in the response. They don't argue at all that the waivers weren't conspicuous. So they don't even make that argument. They don't even attempt.
I think their main argument is that you've waived your right to enforce this. I think that's pretty much it. Is that right, Ms. McIntyre?
Yes.
Yes,
I'm sorry, you were asking Ms. McIntyre.
Yeah.
So yes, just briefly on the standard, they don't even argue the 2 main points that the Texas Supreme Court has said is the standard. The argument that they allege, as Your Honor has just stated, is waiver. So I'm going to cover waiver. Just first, let's look at the facts of this particular case going into the case law cited by the defendants. First, there's no jury fee paid here. Your Honor is very well aware that when plaintiffs file pleadings, we often have standard language that's always included in our pleadings, which was the case here. There's form pleadings that have a jury waiver in there. Certainly, had we not paid a jury fee 30 days before trial, we would have waived our right to a jury trial. And so there's no jury fee paid here. But most importantly, Your Honor, obviously Mr. Riley and his co-counsel don't have the benefit of having been in this case from day one, like the rest of us have been. But this jury waiver has been discussed ad nauseum with Your Honor in multiple hearings. Even from the beginning in the scheduling conference, when we were talking about a trial date, we have made it very well known that we believe from day one that this case was subject to a jury waiver, and we agreed to a trial date contingent upon Your Honor's ruling on this. There has been no secret. There's been no hiding the ball. We have been open and discussed this many times with Ms. Shigaris and Ms. Lopez previously in this case. Again, I know my counsel that's on the case now didn't have the benefit of that, but this has been openly discussed with the court on the record multiple times since this case has begun. Your Honor mentioned that the defendants here rely on River Center. Significantly, that case is a 1993 case before Prudential, and we know what the court held in Prudential, which is that pre-litigation jury waivers are enforceable. And in River Center, that's talking about a mandamus, and the court never even reached the issue that we're at here because it found that a writ of mandamus was inappropriate since they had waited 4 months to even assert their right to a mandamus. So the issue didn't even get reached. The issue that the Prudential court decided did not get reached in River Center. Further, the defendants rely on GE Capital. I want to back up one step. The defendants have acknowledged that this type of inquiry is going to be a very fact-specific inquiry, which is why I addressed the facts of this beforehand. And I'm hoping the court can keep those in mind as we look at this case as well. So GE Capital, in that case, the Texas Supreme Court refused to find a waiver despite GE waiting 10 months to seek the other side's jury demand. So that was a 10-month waiting period. The Texas Supreme Court didn't find waiver.
So I apologize. So as I said before, because of the whatever reason with the clerk's office, I couldn't pull this up. So GE Capital, they refused to find a waiver. We kind of have a double waiver here. So they refused to find that the jury trial was waived or that the parties had waived their right to waive the jury trial.
That the jury waiver had been waived. So my position in this case, they did not side the way that the defendants are asking you to side here. They said after waiting 10 months, there was not a waiver to invoke the jury waiver.
Okay. All right, go ahead.
It's a mouthful. Okay, I think interesting case for the court to consider is the Dallas Court of Appeals decision out of the 192nd District Court in 2005, and that is in re C-SPAN. That case is super interesting. So the lawsuit was filed in 2001. It was set for a jury trial in 2004. There had been 7 scheduling orders that included agreed trial settings. It was a case between Blockbuster and C-SPAN. So 30 days before trial, Blockbuster for the first time sought to quash or strike C-SPAN's jury demand. And the trial court granted that motion, but Dallas Court of Appeals said no and did not find that there had been a waiver even in that.
In this case, did they discuss the issue of whether or not they had waived the right to assert the jury waiver?
Yes, that's what the case was about. And they said there had not been a waiver of the jury waiver. So again, the double negative.
Okay.
So the Court of Appeals essentially ruled in my side's favor on this issue, finding that waiting that long had not been a waiver. And that's way more than we have here. That was a from 2001 to 2004, 7 scheduling orders, and they didn't even demand it until 30 days before the trial setting. Here, we're well in advance of a trial setting. We've talked about it in open court multiple times. We haven't paid a jury fee. So as I mentioned, in the end, waiver is a factual inquiry that the court has to look out to determine if there was an intent by my side to waive the contractual right. And here, it's clear that we've got 3 conspicuous waivers. We've talked about it in open court multiple times. There's no jury fee that's been paid. And in fact, as the case law I just cited, the Texas Supreme Court has refused to find waiver when there's been a 10-month delay. And the Dallas Court of Appeals has refused to find waiver when it was 3 years and had 7 jury settings and was 30 days out from trial. So for those reasons, Your Honor, I don't think that they've even made the arguments that are laid out as far as what the standard would be. But I think even when Your Honor looks at the factual inquiry and considers the Prudential case, River Center is a 1993 case. We've got to look at Prudential. These are very sophisticated parties. And as much as we may not like it, I'm obviously a huge proponent of jury trials, but even as much as we may not like it, parties like this are allowed to contractually waive these types of rights. And I think that's what's happened here. And for that reason, we ask that this proceed as a bench trial. Thank you, Your Honor.
Response? And can you stop sharing, Ms. Pettit?
Yes. It is off the screen.
Thank you. Thank you, Your Honor. Plaintiff's motion should be denied because plaintiffs waived their right to enforce the contractual jury waiver provisions. Now, as Ms. Pettit stated earlier, she said that from day one, she knew that they were subject to the jury waiver. Now, before I begin with the legal arguments, I want to comment on that. And I think it's important for the court to understand the procedural history of this case. Plaintiffs filed their original petition on November 15th, 2019, and asserted a jury demand. Throughout the course of a year and 3 months, they amended their petition on 5 separate occasions and each time reasserted their jury demand. Defendants relied on this jury demand when they filed their motion for jury trial setting and entry of scheduling order on November 19th, 2020, and the court relied on this jury demand when it set this case for a jury trial on November 2nd, 2021 at 9 a.m. But then on February 24th, 2021, 26 minutes before plaintiffs filed this motion to strike, they changed their tune. On February 24th, plaintiffs filed their 6th amended petition and strategically chose to omit their jury demand. Now, this entire time, or to be exact, for a year and 3 months, plaintiffs have been asserting their jury demand. And because of this, they waive their right to assert the contractual jury waiver provisions. More specifically, they waive their right through their intentional, inconsistent conduct and by failing to promptly assert their contractual right. Now, moving to the first point, plaintiff's intentional, inconsistent conduct. As Ms. Pettit stated, River Center was cited as, or included in our response as Exhibit C. River Center is a Supreme Court of Texas case that held that a contractual right to a non-jury trial can be waived. That waiver requires intent, which can be shown through either the intentional relinquishment of a known right or intentional conduct inconsistent with claiming that right. Now, earlier,
Ms. Pettit referenced to 2 other cases that are more recent than River Center, the Prudential case, and then this case out of the Dallas Court of Appeals. How do you distinguish those cases, or do they apply?
Yes, Your Honor. So first, going to the GE Capital case. This case that Ms. Pettit brought up, the court held that after 10 months, there was no waiver because the plaintiffs did not have any intentional, inconsistent actions with asserting that waiver.
Can someone share screen that case so I can see it?
I can get my secretary to pull it up while we talk. Hold on 1 minute. All right. we should have that shortly. Hold on one second. Now, going to the C-SPAN case, this wasn't included in plaintiff's motion and it wasn't included in a reply brief. However, I would be happy to look into this case and provide supplemental.
Is that the Dallas Court of Appeals case she was citing to?
Yes.
Okay. Was that cited in your briefing, Ms. Pettit? You're muted.
It was not.
You're cutting out, Ms. Pettit.
Their defense was going to be waiver. So can you?
You cut out there. Can you say that again?
Sure. We did not know that their defense was going to be waiver, so it was not, the waiver issue was not addressed in our initial brief.
Okay.
However, in the GE Capital case, the main point that the court made was that there was no intentional inconsistent actions on behalf of the plaintiff, and that's why there was no waiver to the contractual right to a non-jury trial. Contrasting that case with here, plaintiffs had intentional inconsistent conduct with claiming their contractual right. Plaintiffs' repeated request for a jury trial for over a year and 3 months was intentional because they requested a jury trial on 6 separate occasions.
In the GE Capital, they did not request a jury trial?
In the GE trial, they did not.
Can you share screen that? Is that the Supreme Court case? I thought it was Prudential that you were relying on, Ms. Pettit. Is it GE Capital is which case?
They relied on, the defendants here relied on GE Capital in their briefing.
And what year is that? Is that a Supreme Court case?
Yeah, give me 1 second.
Hold on 1 second.
Yeah, GE Capital is Texas Supreme Court.
I have the case pulled. I might be able to share it here, Your Honor.
Let me make sure it's enabled. I think I did. It's enabled. Yeah, go ahead.
Okay. Okay, can everyone see that?
That's GE Capital. Okay. So let me see. So in this case, the trial court refused to send the case to a non-jury docket, and then the Supreme Court said they had to return it to a non-jury docket. Is that right?
Yes, Your Honor.
Was there a jury waiver in this? There was a jury waiver. Okay. So explain how this case supports your position.
Your Honor, this case was used to highlight the idea of waiver. That waiver requires intent and intentional actions. And if there is no intent and intentional actions, then there is no waiver. And that's what this case held. Here, there was intentional actions, and therefore there was waiver to the contractual jury provisions. Here, the intentional inconsistent actions was Ms. Pettit and the plaintiff's repeated request of a jury trial on 6 separate occasions.
Can you, Cliff, I'm sorry, you don't have your last name up. So I'm sorry, I'm calling you just
Riley, Cliff Riley, it's okay.
Mr. Riley, sorry.
Okay.
Go ahead and go down on this so I can see a little more. Okay, so it talks about River Center. Okay, keep going. Okay, go down. All right, so it talks about Prudential too. Okay. All right. Go ahead, Ms. McIntyre.
Plaintiffs had numerous opportunities to omit their demand or at least object to defendant's demand, but they didn't. Now, plaintiffs also, and this kind of brings us to our second point, plaintiffs also failed to promptly assert their contractual right. Now, the Supreme Court of Texas has held in River Center that the plaintiff waived their right to assert contractual jury waiver provisions by waiting over 4 months after defendant filed their jury demand to assert any right they may have had under contractual jury waiver provisions. The court specifically said that the record reveals no justification for this delay of 4 months, and under these circumstances, plaintiff has not shown a diligent pursuit of any right to a non-jury trial. Now, similarly to here in our case, plaintiffs waited too long before asserting any right that they had under a jury waiver provision, and as such, they waived their right to a non-jury trial. Plaintiffs demanded a jury trial on multiple occasions, and they made the conscious decision not to object to defendant's jury demand until months later when it suited them. As the Supreme Court of Texas held in River Center that 4 months was too long, 1 year and 3 months is far too long. And as such, plaintiffs waived their contractual right to a jury demand, and their motion should be denied.
So can I see the In re Prudential case?
Yes, Your Honor, I have that one up.
Okay, so you'll need to stop sharing this one. Okay, there we go. And I want to note that I think we'd gone on the record, Mr. Reamer, and you were a little bit late. If you want to go ahead and make your announcement.
Apologies, Your Honor. Yes, Ben Reamer here on behalf of Mr. Nall in Mid-Market.
Okay. And do you have a position on this matter?
I do not, Your Honor.
Okay. Go ahead, Ms. Pettit.
Okay, give me 1 second. I'm trying to pull it up. Here we go. The Prudential case is very long, as Your Honor knows.
Okay.
I'm not sure how much you want me to scroll.
Just get to the point where it talks about the jury waiver.
Pretty much the whole
case. Okay.
Yeah.
To the point about the waiver of the jury waiver.
Waiver, I don't believe. Give me 1 second. I may have a highlighted version that's better. Give me 1 second. And again, the Prudential case is talking about jury waivers in general. Give me 1 second. Okay, may help. I don't have a highlighted version, but I'll get here as quickly as I can. And so the reason why this case is significant is that the River Center, prior to Prudential, there was no confirmation from the Texas Supreme Court that contractual jury waivers were necessarily going to be enforced, which is why this case is so significant, because at the time River Center was decided, we didn't have this particular ruling on jury waivers as a whole.
Does it discuss the waiver of the jury waiver?
I don't believe there was a time, Ms. McIntyre can correct me if I'm wrong on this, but I don't believe this discusses the time period. I think the GE case is the most instructive in regard to the time period. And obviously that relies on, GE is a Texas Supreme Court relying on Prudential. And I think, Your Honor, the reason why GE is so significant, even though it's actually relied on by the defendants, is in GE, even in that case, they had actually paid the jury fee. So the party trying to enforce the jury waiver had actually gone so far as to pay the fee, which certainly hasn't happened here. And the court found that the jury waiver had not been waived. which is
So there's no discussion in Prudential about the waiver of a jury waiver.
Ms. McIntyre can correct me if I'm wrong, but I don't believe the timing of the waiver was addressed. Let me keep scrolling for just 1 second. It was just whether or not as a whole jury waivers were enforceable.
I agree with Ms. Pettit. I don't think that it was discussed in the case, but I'm not positive off the top of my head.
Let me go to the.
Okay, well then let's look at this Dallas Court of Appeals case, and I'm going to allow Ms. McIntyre and Mr. Riley to have an opportunity to, brief that case, but I'd like to see it as well.
Yes, it is up on my screen, Your Honor.
This is the Dallas Court of, that's a C-SPAN case, okay?
Yes, Your Honor. And so what's interesting here, and this case is a lot shorter, so I can get you to the right part quickly, is, okay, so it's this, I note for this particular part.
Okay, so where do you want me to read, Ms. Pettit?
Right here. 1 second. This is the holding here that it wasn't, oops. Can you still see
Technical
it?
difficulties today.
Okay. 1 second here. The part that I just highlighted, this head note 4.
Okay.
And this is the one, it's referring to the facts of the case, and the facts, as I indicated, were that there had been a 3-year wait for the trial. We were, in this case, they were 30 days out from trial, and there had been, I believe, 7 scheduling orders indicating a jury trial. And they said there had not been a waiver.
Well, isn't one of the issues here that was maybe the law was unclear?
I definitely think that was part of the issue that the Dallas Court of Appeals looked at, but they certainly analyzed the factual basis here as well. But though I definitely think that the Dallas Court of Appeals didn't hold the Prudential case against them, because they certainly didn't have that ruling at that time, because it came out during that interim period. One just factual thing I would like to clarify for the record here. I know Ms. McIntyre made a statement that the defendants here relied on our jury demand, and that the court here relied on our jury demand. And again, I'm not holding it against Ms. McIntyre that she wasn't here, but that's just factually completely incorrect, because it was specifically discussed multiple times, including at the scheduling conference early on in the case, with Your Honor, where we discussed this very issue. So perhaps Ms. McIntyre just hadn't been informed by predecessor counsel of hers that this had been brought to the court's attention and the defendant's attention.
Let me, okay, you can stop sharing. Is the case currently set on the jury or non-jury docket?
Well, Your Honor, we agreed to set it on the jury docket pending Your Honor's ruling on this. I mean, that was explicitly, Mr. Reimer, I believe, was there for that as well. So Mr. Reimer may recall those conversations, but we did it subject to Your Honor's ruling on this exact issue.
Your Honor, may I respond?
Yes, you may.
Even if, I mean, that being said, it is true. Obviously, there has been a counsel change with the defendants. Even if that was the case, the plaintiffs have still made their demand for a jury trial on 6 separate occasions, starting with their original petition. They intended for this to be a jury trial. And we relied on that, even as us as counsel, since we've taken over this case in the decisions that we've made. This case was set for a jury docket, and we had made all of our decisions as such.
The only thing,
Well, it's currently, I think, set on, well, I'm confused. It was set on 6/20. When is it currently set for trial?
November 2nd, 2021, I think at 9 a.m.
But it looks like there had been maybe prior settings where it was a non-jury. Is that right? Or
Well, Your Honor, it's a little bit confusing because Mr. Reimer's case was combined, and you may recall those are some of the conversations that we had. I think the
Okay.
defendants, Mr. Reimer, correct me if I'm wrong, but I think the defendants had conceded that all of your case would be tried to Your Honor.
Okay.
And we were waiting to determine whether all of my client's case would also be tried to just Your Honor or also a jury. So we had been back and forth in front of Your Honor on that issue, whether it was jury or non-jury, and how we were going to set it pending Your Honor's ruling on this. The only other thing I'd like to clarify is I understand she's saying we've asserted it 6 times in this case. We filed this case originally. They removed it to federal court. It got sent back to state court where it's currently pending. So I believe it's our second amended petition under this case number, because the prior case number didn't ever exist anymore because it was dismissed, and then we refiled it in this. So I believe it's the second.
In this case, at one point, or part of this case was in the 193rd, is that right?
Yes, Your Honor.
Okay. This is so confusing. Okay. So I remember these discussions, Mr. Reimer, you've been kind of called out here, so not called out in a bad way, but just what is your recollection of all these discussions?
Yeah, my recollection is as Ms. Pettit has characterized it. We had our own scuffle regarding the jury waiver issue. Is kind of the opposite, where we had demanded a jury at the beginning of this case, and Ms. McIntyre and Mr. Riley's clients were trying to strike our jury demand. So it's kind of the opposite way around. Now this is when we were in a separate court. We were ultimately transferred into Your Honor's court and consolidated. And at that time, their argument on the transfer was that I was just trying to transfer so that I could then re-ask for a jury in Your Honor's court, which I never intended to do, and I did not do. We stood by that prior ruling that our jury was going to be waived. But when we consolidated the cases, I think as Ms. Pettit is discussing, we didn't consolidate the Delgado case. I believe it was all kind of a discussion about what's going to be the most efficient for discovery purposes. So we consolidated for discovery, but then we left a lot of these ultimate trial issues, I think, pending.
Okay. And Ms. Krajewski, you're pretty new to the case, aren't you?
I have actually been on this case.
Oh, since the beginning. You've just been so quiet, I guess.
Yeah.
What is your recollection of all this?
So I do recall that there has been, this debate for quite a while. I know that when it was set on the non-jury docket, and I believe then defendant's counsel had emailed you or emailed everyone, because I know that was inadvertent, and that wasn't, in line with the discussions during the hearing. But I believe, there was an understanding to set it on the jury docket, but that with an understanding that this was going to be briefed and come up later on.
Okay. So there was no waiver. Nobody waived the right. Nobody said that they were waiving the right to waive the non-jury waiver.
No, Your Honor.
Well, I was asking Ms. Krajewski.
Oh, I'm sorry.
And I'm saying your name wrong. How do you say your name again?
Krajewski, but that's okay.
Krajewski. It sounds much better than what I'm saying. It's a Krajewski. So was I correct in what I was saying or no?
That's right. That's my understanding.
So what I think I'll do at this point, in fairness to Ms. McIntyre and Mr. Riley, is to give them an opportunity to brief these new cases that were cited, and then I'll try to make a decision on this as soon as possible. So we're currently, this particular case is set on the jury docket for November. Is that right?
Yes, Your Honor.
Yes, Your Honor. The only other thing I would ask Your Honor to indulge is in the event that the court is persuaded that my client, through the filing of the petition, somehow waived the jury waiver, I would ask for time for us to order transcripts of all of the hearings from Ms. Rieger so that we can also point, Your Honor, to all of the discussions that have taken place, many of which I'm sure are on the record, some of which may not be, just as a reminder of the fact that this discussion has been going since the case's inception.
Okay. I mean, do you want to do that now, or is that necessary, Ms. McIntyre, Mr. Riley, or do you dispute that?
I mean, I apologize, Cliff. To be completely honest, this is the first time I'm hearing about these conversations. I didn't know about them. And what's on the record and what is shown from the record that I've seen and the docket is that they've repeatedly requested a jury trial multiple times. And to my knowledge, I don't know about any of these discussions.
I do remember discussions that some of the cases, some of this was going to be covered by the non-jury waiver and some weren't, is what I recall, but maybe I'm not remembering that correctly.
Well, I think predecessor's counsel had a different position on the extent of the jury waiver rather than just the jury waiver as a whole. So I think the reason why the conversation is different is because I think predecessor counsel would have made it a very different argument than that's being made currently.
She would not have argued that the jury waiver was waived. She would have said it just didn't cover certain claims. That is
my understanding of Mr.
I think you're right about that. That's kind of what I recall too, that there were certain claims that were covered in certain.
Your Honor had talked about, well, if Ms. Shigaris is right, then part of my client's claims would go to a jury and part would go to Your Honor. And so I think that's why there was the back and forth that we might need a jury for part of it and not the rest. But that's not the argument that has been posed by defendants at this time.
Your Honor, we think it'd be beneficial for us because we are new counsel coming into the case to review some transcripts. Our argument is that the pleadings control the official jury demands, but we certainly weren't part of those conversations. We'd be happy to review those transcripts now that we kind of know this is an issue raised between the parties.
Okay, well, why don't we do this? I don't know how long that will take. There's been so many hearings on this case, and so it may take you a while to get the transcripts. What I would suggest we do at this point then is I'm going to give Mr. Riley, Mr. McIntyre an opportunity to request whatever transcripts, maybe talk to Ms. Pettit and predecessor counsel on which hearings to request, because there has been a lot of hearings, and hopefully they're on the record. And then once you figured out which transcripts you want to get and you get all of that, then let's reset this for hearing so that we can have a full look at this. Because I think Ms. McIntyre, who did an excellent job of arguing her very first hearing, great job. She raised a good point, which is, was there an intentional relinquishment? So if Ms. Pettit had previously said, and I don't have perfect recollection of this, hey, look, we recognize that the jury waiver doesn't apply, that would be an intentional relinquishment that would be consistent with what was in the pleadings. If she said previously, for example, or vice versa with Ms. Shigaris, that there was not a jury waiver that covered this, then, or that they were not planning on asserting the jury waiver, then that would be a knowing intentional relinquishment, which is what is required here. And so I do think that the representations made by both counsel, Ms. Shigaris and Ms. Pettit, and the other attorneys involved, could be relevant based on Ms. McIntyre's able argument in this case. So does that make sense?
Yes, Your Honor.
Yes, Your Honor.
So, and I just don't have perfect recollection of exactly what was said and which claims were covered. So I think the transcript would be helpful. All right, guys, is that kind of clear?
Yes, as far as timing goes, would you like us to get the transcripts and then reset it, or did Your Honor want to reset it now. I just want to make sure we're following.
I don't want to reset it now because I don't know how long it's going to take for you to get the transcripts, you know, so I think that I'll leave it up to it's whose motion. This is
It's
your
my-
motion, their motion to strike the jury waiver. So let them reset it when they want, once they have all the information they need, and, you know, so let them reset it. Does that
Your
make
Honor, just to
sense?
clarify, the plaintiff is the movement, so plaintiffs will reset it.
Ms. Pettit is, wait,
Yes.
okay.
It-
I thought this was a motion to strike the jury waiver.
It's the opposite. It's the motion to strike a jury trial.
Oh,
my
okay,
side is the one that's-
sorry.
I know it gets all the double.
I haven't
negatives.
seen your motion, so you're right, you're right. So it would be Ms. Pettit. But Ms. Pettit, I'll just be transparent with you. If you decide to set this really quickly before they have a reasonable chance to get the transcripts, then we're just going to be in the same place again. So please give them a
Understood.
reasonable opportunity to get the transcript so that we can so I can make an informed decision.
Understood, Your Honor.
And one other thing I would point out, just something to think about in this case, is I had mentioned before that we're going to be starting up jury trials fairly soon. And once we start jury trials, I'm pretty concerned that I'm going to have a lot of difficulties in reaching non-juries because we're going to be spending all our time on jury trials. And so that is an issue that you guys might want to think about. You might have a better shot of actually, because I always take jury trials before non-jury trials, unless it's a non-jury week. And so if this ends up on the non-jury docket, I would either suggest possibly moving it up, but I would have to move it up quite a bit, or maybe resetting it to next year once we get the non-jury weeks, because the likelihood of us reaching you as a non-jury case in November is very low, assuming we're just doing jury trials. Does that make sense?
Yes, Your Honor.
Yes.
Something just to think about. All right, guys, you guys be safe, and it's good job, Miss McIntyre. It's always good to see you. Good, Miss Pettit, everyone else, good to see everybody. And interns, we'll see you guys at 1:30 for our next hearing.